all set up, which it is. So I'm going to turn it over to the judges and say good luck.
Thank you, Dr. Cosgrove. Good afternoon, everybody, and welcome. I'm Karen Milton from New York. I'm currently the Chief of Staff in the Office of the Metropolitan Transportation Authority Inspector General, which is the state agency that oversees the New York City and Greater New York Metropolitan Transportation System. Prior to that, I worked in the federal judiciary as the Circuit Executive for the Second Circuit, which comprises the states of New York, Vermont, and Connecticut. And basically that means I was sort of the chief operating officer overseeing the 13 federal courts in those states. Believe it or not, spent a lot of time talking about habeas corpus. So I'm really looking forward to today's conversation. And I'm here to tell you, as someone who has made her legal career in public service, you can have a career in public service and still keep talking about habeas corpus. Think of that. I'm going to let my colleagues introduce themselves. Then we're going to ask each of you to introduce yourselves and your teacher. So thanks for being with us. Charlie?
Good afternoon. My name is Charlie Hinderlighter. I'm the Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I'm a past political science professor and farther in my past, a student in the We the People program. So at one point I was on the other side of this, well, I guess proverbial table in this instance. But it is a pleasure to be with you today, and I am for conversation.
Hello, my name is Mark Simons. I'm a practicing attorney and living evidence before you that you can get paid to do exactly what you're doing today. Keep that in your future. You can do something with this. Like I said, I'm in Nevada, looking forward to engaging with you. Smile, have fun, take a deep breath. It's day 2 of the Nationals. Congratulations, you're here. Have fun. Talk to you soon.
I'm Luke Lawson.
I'm Stevie Will.
I'm Caleb Jackson.
I'm Ashley Riley, and we're Unit 1 from Sheridan, Wyoming, here with our mentors Kim Ferguson and Michael Thomas.
Well, welcome to everyone and to your mentor and teacher. We look forward to our conversation. If you're ready, we're ready, and I'll read you the question, and then you can begin with your prepared statement. So, Unit 1, Question 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in these United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Please begin.
No man shall be arrested or imprisoned except by the lawful judgment of his peers and by the law of the land, securing the writ of habeas corpus in the Magna Carta.
Habeas corpus is Latin for that you have the body, and is liberation for those fighting against wrongful imprisonment without sufficient evidence. Habeas corpus is essential to the principle of limited government.
Case in point, before 1215, the monarch would unrightfully imprison and punish innocent citizens. Subsequently, the government eventually rebelled against this power and forced King Edward to sign the Magna Carta.
In order to prevent such happenings in our own government, the founders ensured habeas corpus in Article 1 under the suspension clause, the Fifth Amendment stating a right to grand jury, the Sixth Amendment concerning trial by jury, and the Eighth Amendment covering the rule against cruel and unusual punishment.
Moreover, more power given to the people, especially in trial by jury, takes power from the government and grants it back to the citizens.
Additionally, giving people the power to decide innocence, guilt, and punishment serves as a check on the government for the laws they pass and if the people receive them as just for the country.
Furthermore, the evolution of habeas corpus in the United States does not fall under the traditional meaning of the term evolution, but is rather a record of legal opinions regarding the circumstances under which it may be suspended or its specifics altered and for whom.
Naturally, in accordance with the aforementioned suspension clause, federal disputations of the legitimacy of habeas corpus have been a looming specter in American politics.
In spite of this, suspensions of habeas corpus have been relatively recent in American history.
It is true that, although not officially, habeas corpus was indirectly suspended with the Alien and Sedition Act stripping the citizens of the right to freedom of the press, with the law stating that any people that write, print, utter, or publish writings against the government of the United States shall be punished by a fine or imprisonment.
But the first true suspension of habeas corpus was the Habeas Corpus Suspension Act of 1863, which stated, "Further proceedings under the writ of habeas corpus shall be suspended by the judge or court having issued the said writ, so long as said suspension by the President shall remain in force and said rebellion continue."
Since Abraham Lincoln's fateful order, habeas corpus has been suspended for select portions of the United States 3 times. In areas of South Carolina during Reconstruction, during the Philippine Insurrection of 1905, and in Hawaii in 1945.
Broader cases since the Civil War have had mixed results, but the war on terrorism has allowed a slew of primarily military-based disputations of the application of habeas corpus, such as the Detainee Treatment Act of 2005 and the Military Commissions Act of 2006, removing the constraint of habeas corpus for military prisoners in Guantanamo Bay and Abu Ghraib.
However, cases like Boumediene v. Bush in 2008 overturned the Military Commissions Act in a victory for habeas corpus. These are symbolic of a trend in the philosophical realm, namely the theoretical nature of government and the extent to which habeas corpus places constraints upon it, and the practical necessity of habeas corpus's existence.
Moreover, the writ of habeas corpus has been shown to place an unreasonable burden on the government, specifically in times of national security and emergencies.
Laid bare, the suspension clause states that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. This phrase, however, can be vague and lead to questions about how far this can be extended.
For example, the attack on Pearl Harbor prompted President Franklin Roosevelt to sanction Executive Order 9066. Due to this order, the rights of habeas corpus were suspended to all Japanese citizens, and the government then became responsible for abolishing individual liberties.
Subsequently, this order led to several court cases enacted against the United States government, including Korematsu v. United States and Irabayashi v. United States, where it was questioned if the president had abused his war powers.
Additionally, in 2006, the Freedom of Information Act lawsuit by the Miami Herald forced the Pentagon to release the names of detainees held indefinitely in Guantanamo Bay. 48 names were released, and this act set the precedent for government officials to foreclose any hidden information, thus placing an unreasonable burden on the government. We are now ready to take your questions.
All right, well, let's start out by talking about the Great Writ. So habeas corpus is often referred to as the Great Writ. Do you think it deserves that name? Why does it have such prominence in our legal system?
I believe in accordance with the Fifth Amendment and due process, along with the 14th Amendment and equal protection and due process is vitally important in America today based on the ideology that innocent until proven guilty is such a fundamental right in America, or a belief in America.
It's also an extremely old writ and has been adopted for the purposes of argumentation by a variety of parties. Alexander Hamilton in Federalist 84, perhaps most notably, saying that should be the basis for rights in the United States rather than a Bill of Rights, and which he quotes the English jurist in that, William Blackstone, who says that to bereave a man of life or by violence to confiscate his property without attesting to guilt and so forth would be just so heinous an act as to immediately sound the alarm of tyranny throughout the land.
Right, taking up on the what Steve you had said, that it's not really an evolution but circumstances, and I want to understand how you view the circumstances of the president triggering a suspension versus Congress seemingly the power entity vested with that right. So can you address that apparent conflict?
So back when Abraham Lincoln was president, he did indeed suspend habeas corpus even though he was the president, and this act was originally given to Congress. At the time, though, these circumstances, Congress greatly entrusted Abraham Lincoln as the president to be able to have these powers and correctly use them, in which case they handed them over to him.
So do you think there's any, we've talked about Lincoln's suspension of habeas corpus and at the time of the Civil War, FDR at the time of World War II, both periods of armed conflict in our nation's history. In your view, is there any justification to suspend habeas corpus outside of armed conflict, such as we saw in the past? What about in today's political environment?
Today, along the southern border, we see a lot of immigration, and under the suspension clause, habeas corpus could theoretically be suspended if the immigrants were considered invaders.
On the other hand, if they aren't considered invaders, then based on the ruling of both Hamdi v. Rumsfeld and Boumediene v. Bush, they're inside the United States territory and control, and therefore rewarded with habeas corpus rights.
All right, so talk to me about this nexus between habeas corpus and state government. How does habeas corpus impact our state governments?
Habeas corpus is a right given under the Constitution, which makes it actually the supreme law of the land. And so, as we said in our essay, this can place an unreasonable burden on the government, and not just the federal, but also on the state levels too, as they must abide by these rules and actually don't maintain the right to suspend habeas corpus as Congress does.
Okay, so what, assuming that suspension occurs, what other protections, I think you dealt with some of them, but I want you to flesh this out a little bit more. What other protections are in the Constitution to protect individuals from arbitrary or capricious act by the government?
Well, the Eighth Amendment in the Bill of Rights addresses cruel and unusual punishment, such that if a leader were to suspend habeas corpus, that would not be an area of recourse they would be allowed to take. Would be some sort of an excessive punishment. In that sense, that there is a protection. There's also protections against the government, unreasonable search and seizure in the Fourth Amendment as well. So that it's really, your power is still quite limited, even if you were to suspend habeas corpus.
Furthermore, if those precautions were overstepped, the citizens would retain the right of the First Amendment to protest the government, and in extreme cases, they also possess the right to the Second Amendment, and if it got to that point, would have the right to bear arms and take arms against the government, as seen during the Civil War.
So, can you define for us a little more clearly what exactly is the unreasonable burden you think is placed on the government? You referred to it when you referenced, I think it was the 2006 case where the press in Florida sued for the names of the Guantanamo detainees. What exactly is why was that an unreasonable burden on the government, and how does habeas corpus place that burden on the government?
I think we can see an unreasonable burden put it on the government, especially in Guantanamo Bay, when we consider habeas corpus rights given to them. When we give them these rights, they are given trial by jury and all of the other things, such as cruel and unusual punishment, which we can see in the Fifth, Sixth, and Eighth Amendment. And this places the government on places an unreasonable burden on the government, because this limits the options they're able to take to try and get information out of such detainees in Guantanamo Bay.
It is to say that it gives us let's say, unilateral disadvantage when prosecuting a conflict, where we are forced to take precautions for the well-being of enemy combatants that perhaps they would not go out of their way to maintain themselves.
All right, so I want to follow up on a comment that you made here a little bit ago, talking about the Second Amendment and the right to bear arms in the Civil War. So talk to me, when is revolution justified, and do you think the Civil War was a justified revolution under Locke's doctrine?
Well, talking specifically of Locke's doctrine, we should refer perhaps to Jefferson's sort of restatement of it. A long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce a state or a people under absolute despotism. It is their right and it is their duty to throw off such government and to provide new guards for their future security. So through Jefferson's restatement of the fundamental principles of Locke, you are given these natural rights that are quite literally inalienable. So in that sense, those would be the criteria from a Lockean perspective.
I think during the Civil War especially, they did reserve the right to revolution, as during the time slaves were considered property, even though we consider it differently today. They still felt that their rights were being overstepped and that they should have the right to rebellion against the government.
And this also goes both ways to or if I may complete this,
Go
this
ahead
also
and
goes both ways to cite John Brown or Denmark Vesey's insurrections in their respective states, which ran quite contrary to the Southern insurrection to preserve slavery.
Okay, so time. Yay, good job. Okay, we're going to do some feedback now.
You gave us a lot to consider throughout the course of this conversation. You guys brought up some great examples. I think you guys really did a nice job of looking at that tension between habeas corpus and civil liberties in a time of war, time of conflict. I think that's been a great theme that you were able to elicit throughout your prepared statement, as well as throughout our conversation, which I think is really a central theme when we talk about the suspension of habeas corpus. But you guys brought in a lot of different points of American history. I really enjoyed our conversation, and just wish we had some more time. I got some more questions. I'd love to hear answers.
Thank you.
Okay, I want to start off with, because the presentation of the information is comprised of two points: the substance of what you say and how you say it and how you appear. You guys look fantastic. You present extremely well. I want to congratulate your group. I didn't realize until I heard the applause that the room was full and they quiet as a mouse. That, kudos to that. That was excellent. Now, going back to the substance, I was really impressed with your technical knowledge and your ability to grasp these concepts, and the fact that you took off early. Stevie's saying this is not an evolution. This is a, time and circumstances is what we look at. And I really love that approach to it. Thank you. I appreciate our time today. I think you guys did a great job.
Thank you.
Thank you.
Thank you.
I would echo what my fellow judges said. I thought you did a really nice job in your opening statement of laying out the history of habeas corpus and its development. And I particularly like the fact that you were so precise. It's been suspended 3 times. You really focused us in on each of those things and gave us a good roadmap for where you were going to end up, especially with the discussion of Guantanamo, which is current events and still going on today. So we really appreciated your thoughtful, nuanced understanding of the issue and your grasp of both the historical and constitutional principles involved. So kudos to you and your teachers. It was really nicely done, and we wish you all the best in the competition. Thanks for speaking with us.